the most important thing that a justice does is writing opinions and explaining why the court reached the decision that they are reaching. And if she's saying, well, I haven't really thought about that in my job yet in the DC circuit, well, I don't think that's makes her exactly qualified for the job, because that's what she will be doing.
There's probably no more important duty for a president than choosing Supreme Court justices who serve for a lifetime. Judge Brown Jackson, not Jackson Brown, by the way, is up. I want to talk to Ashley Baker, who's with the Committee for Justice. She's a friend. She's worked on these issues before, that is, getting judges through and stopping judges and how the process works. Ashley, great to have you.
Thank you for having me.
All right. I'm not a biologist, so I'm just going to take a shot here that I'm going to use female pronouns with you, just a shot. All right, that out of all the questions that she answered in her Senate confirmation hearing, that one was the one that I think people could hook onto the most to give some insight as to who she is. When asked, can you give me a definition of a woman? And she said, I'm not a biologist. Well, for me, that was a celebration, because obviously now this question is all about biology and no longer about anything legal. So I don't think she understood exactly what she was answering, but tell me what you thought of it.
Yeah, I think it's interesting which questions she did not answer, and that's the top one that's caught people's attention. And I think it gives a good idea too of who exactly it is that she tries to please, and exactly what it is that she thinks. I don't think it would have been bad for her to answer that question. I mean, how simple is it? Did she not do that when filling out her driver's license, for example?
But I've got to say though, I was impressed by, I'm not going to use the right word, by her presence or stature. Mm-hmm. I have a feeling she will be confirmed. Tell me if you feel differently. You have some concerns about her. I want to get into those, and then I want to get into how this whole process really works, because I have a feeling it works differently behind closed doors than what I think. So what are your concerns about this nominee?
My concerns about this nominee is really just the way in which she will interpret the law and what her judicial philosophy is or isn't. She never really exactly answered those questions very clearly. She walked through what her sort of methodology is to interpret certain cases, but would never answer the question of, what is your philosophy of the Constitution specifically? And I think that's very important.
She said that she was like one of my heroes, Antonin Scalia. It seemed as though she believed in an originalist viewpoint of the Constitution. At least that's what she said. It doesn't seem to jive with some of her rulings. What is an originalist viewpoint of the Constitution? And tell me, does she really have it?
Sure. And, this isn't the first time there's been a lot of, language thrown around that's about originalism and textualism by a nominee appointed by a Democrat. Kagan famously said, we're all textualists now. And as a method of analysis, you have to be, the text does bind you somewhat. That is part of, your job is looking at the text, but where they go from there is very different. And some, Ginsburg, for example, she believed in the living Constitution. She talked about her philosophy and what it was, and at least we knew what that was. And all the other justices have as well. And it's a critical part of her job too, is the most important thing that a justice does is writing opinions and explaining why the court reached the decision that they are reaching. And if she's saying, well, I haven't really thought about that in my job yet in the DC circuit, well, I don't think that's makes her exactly qualified for the job, because that's what she will be doing.
Will this nominee be confirmed?
I think she has the votes to be confirmed, yes.
At this point, once it looks like, and at the time of this recording, there are a couple of Republicans that have signaled that they're going to support her. I don't think she made any major errors in her hearings, except for the biology one. I think will be the one that she will be remembered for. I think she is going to be confirmed. Does that mean that those of us who have concerns about her judicial philosophy and her lack of opinions, that we should just go out, lost this one, time to move on? or do you continue to fight this?
I mean, I'm sure how you can continue to fight it once someone's confirmed. I mean, she was the president's choice, unfortunately, and she will be, the Senate's choice. So once they're on the bench, there's nothing really that you can do about that except for, argue why their opinions are wrong.
Biden's decision to say during the campaign, I am going to nominate a black woman, I just found that to be offensive. No, not because we shouldn't have a black woman on the courts. That's not the issue. Is that you took a pool of qualified people for this position and you narrowed it down to a really tiny window of candidates for the highest court. And people who might agree with your philosophy more, might have better experience, might be better at it, are just out of the running based on their genitals and their skin color. I just found that offensive and completely un-American. And the fact is, he could have still chosen this woman without it being a victim pick. And I think he would have done much better politically. Tell me if I'm wrong.
I think you're right. I think from his perspective, since it was a campaign promise and there wasn't a vacancy, can't be quite as, he couldn't not be specific as a campaign promise. He had to be specific or otherwise, focus on something else in his campaign. But I agree that it's offensive. It is ironic now, too, that she wouldn't answer the question about gender, given how much hype has been around those things created by the president. To be clear, I'm criticizing President Biden for that choice too. And it does, like you said, it eliminates about 98% of candidates. And one person could argue that, well, there aren't enough women in the federal judiciary. That's a problem. Well, maybe that is an issue, but that's not the issue here. And there are plenty of qualified candidates, perhaps more qualified, who are being skipped over. Ironically, too, the Supreme Court just took up a case to reconsider affirmative action. So the Supreme Court has signaled that they are ready to move on from race and gender classifications. Why can't the president do that as well?
Let's get into how this happens. I once had the incredible honor of having dinner with Antonin Scalia, and I just found it fascinating. And I found him to be so remarkably approachable, that he was just a regular guy. He was not a DC creature. Justice Thomas has this same personality, I've been told. When court is out of session, he and his wife are in an RV going someplace around the country, whereas the Chief Justice is obviously a swamp creature. He loves how he's perceived inside the Beltway. How is this chosen? Who looks at all the judges? Does a Supreme Court nominee have to be a sitting judge on a someplace? Does he or she have to be a lawyer? What are the qualifications?
Well, they don't have to be a sitting judge. For example, Justice Kagan was Solicitor General. So it would be drawn from a pool of sitting judges. That's just the logical place to find someone who would be, a good Supreme Court justice. But there have definitely been exceptions to that. There is certainly a trend of having the DC circuit is really considered sort of the feeder circuit for Supreme Court nominees. And I've always said that all things being equal, if there are two nominees, they're both equally qualified. I agree with them both in a hypothetical world. Pick the one that's not from the DC circuit.
All right. Give me the behind the scenes skinny, though. It's not like the president comes up with his list of nominees. He has people who must, before he gets sworn in, start working on lists of who would be good potential nominees. Who does that work? And I'm also assuming it's not just his guys inside, his own system. There's got to be pressure groups and advocacy groups and good government groups that are all trying to get the ear of our president to say, here are our top picks. You ought to choose from this pool. How does that work? And have you been involved in it?
Well, that's the job of the White House and the Office of the White House Counsel's Office. And they do rely on people from the outside in terms of it's impossible for one individual to review, for example, all the opinions of all the prospective nominees, Judge Kavanaugh, I believe, had 300 and something written opinions at the time that he was nominated. So one trend is that clerks tend to send materials that summarize the positions, the opinions of their and qualifications of their judges, which is helpful in terms of summaries, but of course they advocate somewhat for their judge. There are outside pressure groups who want to pressure the White House to nominate a nominee who they think will rule a certain way, and we've certainly seen that here, and certainly seen that, well, starting with Bork's hearing. But ultimately, it's the job of the White House. It's not that there are outside groups and they say, you know, give us a list, we're going to make this our definitive list. It's a combined effort of things.
But I think about something like the Federalist Society, which is just a really important organization of more originalist thinking lawyers who connect. And Leonard Leo, who was, I believe, the head of that group for a while, was a real advocate and helped Trump narrow down lists, if I understand this correctly. And I'm thinking, if not for the Federalist Society, we wouldn't have had some of these really impressive picks. There's no way that Trump on his own or his team would have been able to come up with that. So I'm grateful that there are people out there doing that, and I'm sure it happens on both sides. Is there something we ought to know about it? Where do I send the $20 check?
No, I mean, the Federalist Society, that is a logical group that any judge who is nominated by a Republican president would be part of. The left has the American Bar Association, by the way, which certainly leans left. And on the right, I mean, the Federalist Society is somewhat, a hub of discussion and was at the helm of the conservative legal movement more broadly. You
mentioned Bork. I'm old enough to remember it like it was yesterday. Before Bork, everything seemed to be respectful and not personal. When Bork was attacked, it was ugly, and it turned the nomination process into something ugly. And I know that every kid who goes to law school is drilled into their head that most important thing you could ever do in life is to become a judge. After seeing what happened to Bork, after seeing what happened to Clarence Thomas, seeing what happened to Kavanaugh, seeing what happens to a lot of these folks, you got to wonder if this is really a role you want to take. What changed? How did it change?
Sure. And the Bork confirmation, I mean, that was mostly, it was the politics of the situation. And by the way, President Biden, who was then chair of the Judiciary Committee, had a lot to do with the fact that that hearing was really taken off the rails by Senator Ted Kennedy at the time. And things had been building up there for a while. And it's a combination of factors, but that was really the first, that was really the beginning of it all, I would say.
And is anything off limits now?
Well, anyway, I think we saw during the Kavanaugh confirmation that clearly it's not.
All right, help me understand this one. This is the $65,000 question, which is worth a lot less due to inflation than it used to be when I was a kid, but still. Why is it that nominees from Republican presidents over time seem to drift towards the left, whereas Democratic nominees never seem to drift towards the right? Sandra Day O'Connor, first woman, again, elected or nominated by a Republican. When the Kelo decision came out, she's on the wrong side of it. I think of the Obamacare decision, wrong side of it. I think about the election, McCain-Feingold election campaign reform laws, wrong side of it. It just over and over we see Republicans who nominate these guys. These guys drift this way. Why?
It could be a number of factors, and it varies by justice. I mean, why Justice Souter, for example, drifted leftward versus O'Connor, those can be attributed to a combination of different things. One is appointing nominees that can't be attacked as much, as in they have less of a paper trail. That also means that you know less about what they really
What do you mean
decide.
less of a paper trail? Explain that.
Yes, in terms of easier to confirm. Yeah, and that's the product too of the judicial nomination process. And then there's also, particularly with the Chief Justice, and I'm not implying that this is the sole thing at work with Chief Justice Roberts or any other historical Chief Justice. There's this preservationist instinct too, towards there's outside pressure by the president, by the Senate to reform the courts, to do other things, and they kind of they tend to drift because of that the most.
All right, so you said a couple of things that I need some help with. You said paper trail. And so if somebody is like Antonin Scalia and his rulings are very clearly originalist, that is, I look at the Constitution. I remember him once saying, I don't believe the Constitution was written on paper. I believe it was written in stone. And you have to read it as it was written in the time it was written. So when you say paper trail, do you just mean a whole bunch of rulings that he has made, or is it that somebody like that might be much more outspoken and at conferences say something like that, which will get him in trouble later on?
Well, a lot more written work, whether that be opinions or extrajudicial writings. The more work there is on paper, the more there is to criticize and have an issue with the nominee.
And why don't any of the ones nominated from a Democrat ever move towards a free market, limited government point of view? It seems like one over the course of so many years, nearly 250 years, just name one.
Well, yeah, that's a good observation. I mean, those who are appointed by the left, they do kind of march in lockstep, and that's part of it's because they believe in the a certain amount of flexibility in a living constitution, and are going to be guided by their party and not by the text itself. And just like Scalia said, it's written in stone, and that's what we believe as originalist, is that text has a fixed meaning. Otherwise, it doesn't bind anyone. And how is the chief executive bound to the Constitution if it doesn't have a fixed meaning? How are heads of agencies bound to the Constitution?
Let me finish up on this one. During the campaign, there sure seemed to be a lot of talk about packing the courts. Mm-hmm. If my history lessons were right, the only time that really came into effect was during FDR, where, again, like Biden, FDR had control of the president, the House, and the Senate, and therefore the threat was, since these old guys are not doing what I want them to do, I'll just expand how many justices there are, and we'll appoint a whole bunch of guys that I like. That never came to be. It didn't happen. But once the threat was made, interestingly, those justices sure ruled a very different way. They towed FDR's line a lot more. This nominee, Judge Jackson, really tap danced around the issue of how she felt. She kept saying, I don't, that's Congress's job. Well, yeah, that's Congress's job and the president's decision, but you have a decision on this. You've been a judge. You must have an opinion on it. And she was very cagey. So talk to me, how real is the threat, and why wouldn't she talk about it?
Sure. And I mean, I think that she should have talked about it because it does involve the judiciary and the Supreme Court, and is therefore very relevant to her role. Back to, you started with FDR, and I would note that court packing was a very unpopular plan at the time, too. It's never had a large amount of popular support. And the goal of court packing is to make the threat to, like you said, they did start to rule a certain way, and that was in favor at the time of the New Deal. And I referred to earlier about how justices have a certain degree of a sort of preservationist instinct towards the preservation of the institution. The court is an institution, and that's very much a threat to that.
You said preservationist. It's the second time you use the term preservationist. I don't think I know what that means. When you say justice is a preservationist, what does he want to preserve?
The Supreme Court itself, the structure, whatever that may be, in reference. But the number of justices, the amount of control Congress has in influencing that sort of thing. Is that
I mixed that up a little bit, perhaps, and educate me on this. Chief Justice Roberts seems to be very, very concerned with how the elites view him and how the court is viewed by lawyers and academics and the rest. He seems to be very concerned about the imagery amongst the ruling classes. Whereas somebody like Antonin Scalia or Judge Thomas, they just wanted to make the ruling as based by the Constitution and didn't need to water it down a bit because it might seem politically too much. They just went to the compass of the Constitution and would go yes or no. And so is Roberts the preservationist? Does that mean moderate in decision making?
I mean, perhaps that could be his excuse there. I mean, I can't really get inside the Chief Justice's head, but just because a certain opinion causes some outcry from whether that's the general public, from activist groups, that doesn't make it a crisis of legitimacy for the court itself. There are some rulings in which the role of the judges interpret the law, and sometimes that doesn't put you on the sympathetic side of things, and that doesn't represent any sort of legitimacy crisis. The media obviously is on the side of the left and these cases, and like you said, some do care a lot about what the New York Times will say about them.
There's nothing in the Constitution, at least when I read it, that set out the number of Supreme Court justices. How did we get to 9? And it's been that way now for 100 and something years. We've had less, and I don't know if we've ever had more, but where did the number come from?
That's just kind of where it landed. It's a matter of, I referred to earlier about westward expansion and the judiciary as we acquired more territories as a nation, moving west, and that also makes it a larger geographical area, not necessarily proportional to that, but that does mean a higher caseload, and that became kind of the way of breaking things down. At one time, there was a practice called circuit riding. The circuit courts would essentially operate when two of the justices as on the circuit court, and they would each be assigned, and that practice was thrown out about 100 years ago or so, and replaced by the federal courts that we have today.
One of the things that it has taken me a long time to understand is that court decisions and courts are not binary. That is, as a political junkie, either this bill passed or it didn't pass, or this candidate won the election or she lost the election. It's all like this, but I have found the more I've been involved in lawsuits and political legal actions, that a judge rarely rules blank. It is a little bit of this, it's really mushy. It's really annoying. The Supreme Court used to come up with these god-awful, I don't know what you call it, but if 3 out of these 4 things happen, then the case goes this way. So is this a free speech case?
Test, yeah.
Yeah. We now have a test, and the test is if the case goes this, this, and this, but not that, and that, then it goes this. Instead of a very clear-cut thing, no, of course that person has the right to burn a flag, or vouchers in education are constitutional. And it's not under these cases, it just is. So is it changing? Are the rulings becoming clearer?
Well, that's a complicated question. There are a lot of things at work there, and just naturally as case law is developed, there's more to go back to, and some of that's good law, some of that was good interpretation, some of it's more complicated, is more like the test that you cited, whether or not that test still holds up, whether it applies, and they are to some degree bound to precedent, or at least to correct precedent. And also it's a matter of Congress writing clear laws. Congress has not done their job, particularly in the past couple of decades, of writing clear law. And that does make it a bit harder. And then some of the cases come down to what particular question was granted in the cert petition. Sometimes it's a very narrow one, and often is a very narrow one. Sometimes it's more procedural, whereas the case has something that's more of a hot topic and then is sort of misrepresented, therefore.
What is if you could boil it down, what is the one thing about this whole system of the Supreme Court, not just including the nomination process, what is the one thing that most Americans just don't quite understand? If you could wave the magic wand and say, everybody needs to know this, what do you think that might be?
I don't know. That's a really good question about the court itself or about the confirmation process. It's hard to say sometimes how much each member of the general public would know necessarily about the confirmation process. But about the court itself, I mean, I think it's important to know why it's important that we write our laws down, that our laws are binding, why the text should have a fixed meaning, and really those points of why we have, the judicial philosophy that we have.
For me, it might be something like, you should know the court, if doing their job right, is not choosing right or wrong. They are choosing constitutional or not constitutional. And if it is wrong, then the Constitution needs to be changed, not the ruling. And from my point of view, I worry that people want the judges to do what they feel is right in the moment. That's a temporary thing. You have to have a system of laws, and they are the referees to say, no, the law says this. It might be a bad law. The Constitution might be completely wrong in this area, but that's what it says.
Well, a lot of it's at fault, too, of what the senators choose, because it is aired on TV. For example, in Justice Gorsuch's confirmation hearings, as much of a record he had in so many cases and opinions there were to talk about, the centerpiece of the hearing kind of became this case about a trucker who almost froze to death. And that makes for a sympathetic person to, tell a story if you're Elizabeth Warren, for example, but isn't exactly a very fair representation of what a judge does or of the case in general.
People want to get some more information about the Committee for Justice. Where do they go?
We go to our website, committeeforjustice.org.
Committeeforjustice.org. Ashley, it is always a kick talking with you. I always learn something terrific. So keep up the good fight.
Thank you. Thanks for having me.
If you enjoyed that conversation, by all means, click one of these other great programs. We have the best conversations with the most fascinating Coloradans. And subscribe to our channel. Just click down below and hit that little bell button too. You don't want to miss a single show.